welcome everybody. My name is Hugh Stowe. I'm a commercial barrister with over 20 years experience in most jurisdictions. But as a bit of a side hustle, I act as a consultant for Loquitur. And Loquitur is one of the leading organisations in the country providing what's described as witness training to experts and to lawyers. And they occasionally engage barristers like me to provide presentations to experts and to lawyers. We can flick on down. And the purpose of this presentation is addressing the ethical limits of witness training. So what can be done by lawyers with you in order to enhance your reports, and what are the prohibitions? What are the dark areas where you can get into trouble? And just to foreshadow the gist of this presentation, the line between what is advantageous and ethically permissible and what crosses the line into ethical impropriety can be very vague. And that creates real danger, both for lawyers and for experts. And there are plenty of cases now where experts have been excoriated by judges for crossing that ethical line. Now, I write quite a bit in this area as well, and my first article, I kicked off with this great quote by Applegate, and that is, even though witness preparation occurs in practically every lawsuit, it is almost never taught in law school, not directly regulated, seldom discussed in scholarly literature, and rarely litigated. Witness preparation is treated as one of the dark secrets of the legal profession. The resulting lack of rules, guidelines, and scholarship has created significant uncertainty about the permissible types and methods of witness preparation. That is worrying news for lawyers, and it's equally disturbing for experts. So that just gets through the overview of what we'll be addressing. We might just kick on because time's a bit tight today. So what do we mean by witness preparation? It's a fairly fluid term. The concept of witness preparation is a useful umbrella concept that encompasses any communication between lawyers and experts and prospective witnesses that's intended to improve the substance or the presentation of testimony offered by that witness. But it can be broken down into two useful subcategories. The first we call evidence proofing, which is effectively substantive evidence preparation relating to the preparation of proofs or drafts or reports of evidence. And the second one we sometimes describe as witness training, which is an expression used to describe practical training to help witnesses to deliver their evidence in court effectively. And this is also called witness familiarisation. So this presentation addresses that second dimension of witness preparation, witness training or witness familiarisation. Now, I want to kick off by just indicating the inherent ethical tension that exists in this area from a lawyer's perspective, but it also affects the experts. The first point to note is that effective witness preparation, effective assistance of experts in preparing their reports, is ethically critically important for lawyers. Rule 24 of the Solicitor's Conduct Rules provides that a solicitor must act in the best interest of the client in any matter in which the solicitor represents the client. And the failure by lawyers to engage with experts in expert report preparation might clearly compromise the discharge of that duty by a lawyer to their client. And that's because, without any disrespect to anybody in this room, the reports prepared by some witnesses are sometimes truly awful. And assistance is really required by those without forensic experience to help them understand what are the rules of admissibility and how can that report be presented persuasively. That said, there are inherent ethical dangers of witness preparation. Rule 3.1 of the rules provides a solicitor's duty to the court and the administration of justice is paramount and prevails to the extent of inconsistency with any other duty. And the reality is that many processes of witness preparation where lawyers assist experts in preparing their reports, in preparing to give evidence, has an indisputable capacity to compromise the integrity of the evidence. And that's because of this recognised phenomenon of adversarial bias, where consciously or unconsciously, and normally it's unconsciously, experts can be swayed by gentle or not so gentle nudging from solicitors. And that just reflects the fact that there is this inescapable ethical tension that exists in the interaction between experts and lawyers in the preparation of expert evidence. And witness preparation is both, firstly, an essential tool for the elucidation of truth in an adversarial system, but secondly, it is also a tool of truth's distortion. And it's not just a matter of ethical considerations when we're trying to explore what are the limits of interaction between lawyers and experts for preparing a report. There are really critical strategic dimensions that overlay or underpin these ethical considerations. And that's because irrespective of whether a particular aspect of witness preparation may technically cross an ethical line, the fact is it may be perceived by a judge as doing so. And if it does, if there's a perception that an expert has been unduly under the sway of their lawyers, that is simply catastrophic for the credibility of the expert. And the difficulty there is that because the line is sometimes a little bit blurry, it can be very risky pushing preparation up to that ethical line. So just dealing with the formal ethical framework. Now, this is what regulates lawyers in the interactions with you, but by implication, you're swept up in those ethical restrictions. So this is what they say: a solicitor must not advise or suggest to a witness that false or misleading evidence should be given. 24.1.2, coach a witness by advising what answers the witness should give to questions which might be asked. 24.2, but a solicitor will not have breached Rule 24.1 by expressing a general admonition to tell the truth, questioning and testing in conference the version of evidence to be given by a prospective witness, or 3, drawing the witness's attention to inconsistencies or other difficulties with the evidence, but must not encourage the witness to give evidence different from the evidence which the witness believes to be true. Now, that seems tight and technical, but it's actually quite confusingly structured. So we've got a general prohibition in 24.1. You cannot advise or suggest false misleading evidence, that's clear enough. Or, quote, coach what answers the witness should give, ambiguous. Next, there's a safe harbour from that prohibition, which means that questioning and testing the version of evidence to be given by a prospective witness is okay. But there's a qualification for that safe harbour. You must not encourage the witness to give evidence different from the evidence which the witness believes to be true. Now, there is just a degree of ambiguity about the way those rules will play out. And that leads to this proposition: it's not always possible to state general rules as to where the line should be drawn, and whether preparation amounts to coaching is inevitably a matter of degree and is dependent on the facts. So that should all make us all, lawyers and experts alike, just a little bit nervous as we engage in interaction. Next. Now, what are the categories of witness training? There is no official taxonomy of what is involved in witness training, but it's useful to identify these different dimensions. Firstly, there's general advice on court process, there's general guidelines for giving evidence, there's non-case-based mock cross-examination, that is, examination on facts unrelated to the case on which the report is being presented. There's preparation regarding the substance of evidence. Then there's case-based rehearsal, of cross-examination. Now, dealing with the first one, general advice on court process, category 1. This is uncontroversial. It's uncontroversial and essential that witnesses be advised and trained in relation to the bare aspects of court process. And that reflects that witnesses clearly should not be disadvantaged by ignorance of the process or taken by surprise at what happens when they finally get to court. Category 2, general guidelines for giving evidence. Again, it's uncontroversial that it's both permissible and appropriate that general advice be given as to the manner of answering questions, as distinct from specific advice as to how specific questions in the case should be answered. Now, for those that came to the first session that we had a detailed list of some of the golden rules of giving evidence, what you should try and strive towards, what you should always strive to avoid, and just a helpful checklist to get you ready and prepared for answering questions. We won't go through those all now. It's part of the earlier presentation, but just a couple. The golden rule, and the golden rule is clear and essential. Just tell the truth. Focus on answering each question accurately to the best of your recollection or knowledge. Don't worry about whether your evidence is good or bad in the context of the case. Never sacrifice your integrity for the purpose of seeking to advance the case in a way that transcends the truth. And that is the rule for all witnesses, absolutely fundamental, as we all know, for experts. Listen very carefully to the question. Answer precisely the question that is asked. Do not answer the question that you wish you were asked or expected to be asked or expect next to be asked. Now, that all sounds banally simple and obvious, but it's incredible how many witnesses, lay and expert alike, come to court with the script that they wish to tell, and it really doesn't matter what question is asked. It is simply the trigger for the mouth to open, for the words to tumble out, and it may have absolutely no connection to the question that is asked. And it just makes a shocking impression on the judge. Such a witness will be regarded as somebody who's not there to help the court or the judge, but is simply there to push the barrow, to tell the story they want to tell. And it's critically undermining of credibility. Another example there, never answer a question you don't fully understand. Don't be embarrassed to say you don't understand and request that it be rephrased or clarified. And that's important because a lot of people that come to court, some might say quite rightfully, have a lot of respect for barristers, and they assume that any question a barrister asks is very carefully crafted, a very smart question from a very smart bloke. And if they can understand it, they think, shit, I must be pretty stupid. And nobody wants to admit their stupidity by asking questions to be repeated. And so not comprehending what the hell they've been asked, they again might just let the words tumble out. And needless to say, when the transcript comes to be reviewed, the judge has no idea, that the expert had no idea what the question was. So never be ashamed to ask for the question to be clarified. And understand a lot of us barristers are kind of silly, and a lot of things we ask are very poorly expressed and phrased. So don't give us too much respect. Thanks, man. Now, one aspect of guidelines for giving evidence is familiarisation with the cross-examination techniques that you can expect. And it is ethically permissible and strategically extremely useful to school witnesses in the strategies of cross-examination and the techniques that are available to manage those strategies. And this reflects the basic recognition that skilled counsel brings to court a saddlebag of techniques for cross-examination. that are specifically designed and employed to make you look stupid and to trip you up when there's no justified cause to do so, and to secure unjustified hits on your credibility. And unless witnesses are aware of the techniques that can be used against them and are aware of the strategies to combat those techniques, they can be unfairly disadvantaged. And their presentation of their evidence will be unduly prejudiced and compromised, and it won't receive the full probative value and respect that it potentially deserves. The next category here is non-case-based mock cross-examination. So this is just experimental cross-examination on a hypothetical set of facts. It's got nothing to do with the facts of your case. And that is ethically permissible and strategically extremely useful. It is one thing to be aware in the abstract of the type of techniques that might be used in cross-examination and how you might manage those if you're exposed to them. But it's a profoundly different thing to actually experience being cross-examined and to be aware of where you might feel a little bit vulnerable and what might be done to try and address that vulnerability. But the key to the ethical innocence of this process is that it's based upon hypothetical facts that have nothing to do with the facts of your case. Category 4 is the preparation regarding the substance of your evidence. And this really overlaps with the first dimension of witness training we talked about, which is evidence proofing. But the waters get a little bit ethically murky in this context. There's absolutely no doubt that some preparation in relation to the substance of your evidence is permissible. It's a little bit more uncertain about where those limits are. It's possible to identify some safe harbours. And the following has been recognised in authorities as being ethically permissible. A brief discussion with a witness of his proposed evidence to clarify some points of ambiguity or uncertainty may be perfectly sensible and desirable in promoting the integrity and accuracy of the trial process. Directing the witness's mind to the point about which questions may be asked. Drawing attention to significant contradictions, errors, and gaps in reasoning. Testing the witness. Although some of you might be thinking, made by testing. We'll explore that a bit later. So that are the safe harbours. Next. What about conduct that falls outside those safe harbours and is clearly prohibited? The repetitive drilling of a witness to a degree where his true recollection of events is supplanted by another version suggested to him by an interviewer. That would apply also to being drilled about expert opinion. Advising what answers the question the witness should give to a question which might be asked. Thirdly, there's some authority for the principle that rehearsing, which is cross-examination on the report, is also prohibited. Now, although not without contestability, I consider that the legitimate scope of testing of evidence includes the following. Questioning experts about the appropriateness of assumptions and the soundness of reasoning and the correctness of the conclusion. So from my perspective, it'd be entirely permissible for you to give me an expert report and I say to you, I note that your conclusion there is based on assumptions A, B, and C. But what is the basis for assumption C? To what extent have you taken into account matters X, Y, and Z? How is that consistent with the conclusion that you've reached? Explain to me the reasoning process from those assumptions to that conclusion. I raise for your consideration that there's a flaw in that reasoning process. What do you say to this? You say your conclusion is X. Can I just raise for your consideration an alternative conclusion? Why? What's your response to that? So it's really getting into the weeds with the expert. It's asking you to consider something contrary to what's in the report, but subject to the next page. In my view, it's permissible. When testing the evidence of an expert, my view is that lawyers need to be mindful not to engage in any conduct which could be perceived or which in fact could pressure the expert to adopt a particular proposition. And to avoid pressure, the lawyer should not express questions in a leading manner wherever possible. They shouldn't be saying to you, surely, Mary, assumptions A, B, and C are ridiculous. Surely the appropriate assumptions are X, Y, and Z. They shouldn't unduly repeat the question until you deliver the right response. They shouldn't personally advocate the correctness of a particular proposition. They shouldn't highlight to you the strategic importance of just tweaking that opinion just a little bit in order to satisfy the strategic objectives of the case. And they shouldn't argue with you about the correctness of your evidence as opposed to merely testing it in the way I described. And I should just say that if there is any conduct which you perceive as involving that kind of pressure, then it's really important that you ask the lawyer to desist and that you feel uncomfortable about those practices. And if it continues, then discontinue the comments. Category 5, rehearsal of cross-examination on your report. Now, this is a very controversial area. And the prevalence and ethical limits of the practice diverge widely across the common law world. In America, you can really do anything with a witness, including rehearsing cross-examination, so long as you don't leave really bad bruising. In the UK, they're very precious, and the idea of rehearsal and cross-examination would be just abhorrent. In Australia, in Sydney, there are authorities which say you should never rehearse examination on the actual report. Nonetheless, it's a practice which happens really quite commonly in the Sydney Bar. What are the arguments against rehearsing on the actual report? So a mock cross-examination on the actual report. The most compelling arguments against the practice are the inherent vulnerability of all witnesses, including experts, to suggestion during the rehearsal of evidence, and the inevitability of there being suggestions made in the course of this mock cross-examination. So it's been recognised in some authorities that rehearsal has a greater potential for suggestiveness than other preparation techniques. A witness naturally feels apprehensive about an upcoming experience. The inclination to welcome a script is strong. Furthermore, repetition of a story, brackets, or an opinion, close brackets, is extremely suggestive. And the reality is, as experts, you would like to feel you are pillars of robust independence. I'm sure you are. But everybody is vulnerable to the cancerous, insidious impact of adversarial bias, where everybody involved on one side of a case unconsciously molds their views in order to accommodate the strategic needs of their client. And the other point is that the benefits of rehearsal of cross-examination on the report can otherwise be substantially achieved without the risks of rehearsal. In particular, that can be done by mock cross-examination on unrelated hypothetical facts. So that can drive all of the virtues of just alerting people to the types of techniques that can be used, give people an actual experience of dealing with those techniques, but it doesn't carry any of the downsides in terms of the inevitable suggestibility that's involved in cross-examination on the actual report, the actual case. So where do I land on the rehearsal of cross-examination on the report? It's a finely balanced strategic question, ethical question. I've previously published articles expressing the conclusion that on balance, although it's controversial, it's by no means clear, I think mock cross-examination reports should be ethically permissible, subject to certain conditions. But I now consider, on further reflection, that that's the wrong conclusion. And both on an ethical basis, because it carries too much ethical risk, and also purely on a strategic basis, because given that there are some judges who will take a dim view about cross-examination on the report itself in advance of the trial, there's a risk that you'll take a credibility hit if that practice is engaged in prior to the trial. And so on balance now, my view is that it shouldn't be undertaken, but that still leaves open the possibility. And in my view, this huge strategic desirability of experts and witnesses being exposed to mock cross-examination on hypothetical facts, just to get them familiar with what that process is, and to generally just get them confident and ready to do the best they can in the presentation of their evidence.
Sorry, you had a quick question.
Yeah.
As you've been talking about it, the report's finished and trials looming and cross-examination, I guess to an extent when you issue a draft report, I guess there's a quote-unquote testing of the report as well.
Definitely.
Is there any sort of guideline in relation to that?
Well, that's the one that I tried to deal with in, I think it was 4, testing the substance of the evidence. So yes, there are restrictions. You certainly can't pressure the expert to change. But there are safe harbours which include this idea of testing and pointing out contradictions and errors in the report. So that's permissible. And also, this is not done significantly in this seminar, but in other seminars about report writing. I also sort of convey the view that I think it's quite permissible, for example, for lawyers to write back to you and give you comments on the report, to raise questions for your consideration. And after the first report has been drafted, I think it's quite okay for lawyers to sit down with experts and to settle the report. But desirable though that there be statement in the report about the nature and the extent of the lawyer's involvement, because now some cases are saying if there's no disclosure of the role of third parties in the actual physical preparation of the report, that can count against the witness in terms of credit. So to summarise, what is ethical witness, expert witness training? It's not proving or witness preparation by the witness legal team. It's a separate service or activity which complements rather than replaces the formal proofing process that's conducted between lawyer and expert. It's certainly not coaching the witness what to say. It can involve independently provided practical training for witnesses to help them deliver their evidence effectively. It's done in compliance with guidelines, with guidance in cases, and it's common in best practice in both the UK and America, and it's becoming a more common phenomenon in Australia. And it can be done in anticipation of an upcoming trial, which is a particular report that's at stake, or it can be done preemptively as part of experts' ongoing professional training and development. And that's some of the services that Loquitur offers to experts. In terms of the course materials that would be ideally used in a witness training type process, it's, as we discussed before, it's critical that those materials be independent of any live or anticipated proceeding. And this is particularly so when the training is done in anticipation of imminent or or trials. Where the sessions are conducted as part of the just ongoing professional development of experts, it's possible, and Loquitur can do this, to tailor materials that are particularly relevant to the particular expert in question. But also it's possible to use some generic materials that can be used by experts of any area. Next. In terms of the ethics of it, the first point there says it should be conducted by an independent third party. That's not essential. If you're engaged by lawyers, they can do it as well. But the advantage of getting an independent lawyer to deliver the process and the program is that it avoids any risk that there might be some perception of impropriety in relation to the tainting of the particular evidence at stake. And through Loquitur, the instructor will be an independent, practicing, experienced barrister, and critically independent of the substantive issue of dispute. Yeah.
Should the trainer know about the subjects to be well trained? Or?
Well, the approach that I take when I'm engaged through Loquitur to provide this service, I won't know, I won't ask, and I won't be told about any dimension of the case, just so it could never be suggested that I have somehow coached in relation to the underlying evidence. And that reflects the fact that it's quite appropriate to be asked in cross-examination, have you undertaken any program of witness training or witness familiarisation? And if you say yes, then that'll be probed further. And it's very nice to be able to say, well, yep, and it's by a handsome bloke who had nothing to do with the case in question. So there's no issue.
But other than the case, like for example, should you learn about specifics about data analytics versus accounting? Yes, the person who knows the subject.
Yeah, it's one of those things that no doubt the more specific the subject matter, the more closely aligned it is with the particular expert jurisdiction involved, the better, because there might be some standard lines of questioning in those particular areas that are highly relevant. That said, for example, that said, there are really generic issues that are involved, generic techniques that might be used in cross-examination, generic strategies for trying to manage those, and they all in a sense transcend the particular subject matter of the report. And so a lot of value can be derived from just the use of a generic set of facts. And from the point of view of the organisation, if you want to engage somebody to cross-examine on a particular esoteric report, there'll be a lot of time involved in that process, so it will be a more expensive process to do. So the benefits of expert witness training generally increased witness confidence and experience. So you're able better to do justice to the underlying strength and value of your opinion. You will have a reassurance, and so will your clients, that you will be able to present your evidence the best way possible in court. It promotes an openness of justice in the sense of demystifying the whole court process. It may lead to time saving in the lead up to trial and not divert the attention of your instructing lawyers away from other critical tasks of preparation. And it allows, in some contexts, a degree and type of practice and training that may be slightly difficult if done by your own lawyers in a particular case. And this sort of stuff can be incorporated into an expert's ongoing CPD program. Next. So do you need to disclose it to court if you've done it? Yeah, you do, and there's nothing at all to be ashamed about. You should be aware that all documents that are used in that training process are potentially disclosable in ways in favour of them being bland generic documents. All right, so to just conclude on that, the aim of a witness training course is to give the witness familiarity and confidence in giving their oral evidence under cross-examination and allow the court to get the best evidence possible from that witness. And in that context, facilitate the ultimate adjudication of truth. Yep. Next. I think that's got us there. So this just indicates, if anybody's interested, the types of courses that Loquitur makes available to experts individually or expert institutions that have a stable of experts within them. There's a basics, which I think this is part of that basics. There's also a module on report writing. There's a module on cross-examination. Some of you have already undertaken, and expert witness for organisation. Just a refresher course before going to hearing. So if anybody has any queries about that, then they can contact Tom Levin on those contact details. All right, well, I think that's it, which brings us to the mock cross-examination. So Vivian, I love that expression. What's it called again? She's voluntold. Excellent. All right. So we'll keep you there. I'm getting most of the thing. Okay. All right. So has everybody had a chance of looking at the fact scenario? Basically, what we've got a contest between a caterer who runs a high-end restaurant business in the Flemington area down in Melbourne. He's offered his catering services. He's Mr. Jones. He's offering his services to Mr. Smith, who's organising a tent at the Melbourne. And it's a very important gig for Mr. Smith. And Mr. Smith reckons that the presentation of the catering was an absolute disaster and a fiasco. And he's suing Mr. Jones over what he regards as the shocking catering. And part of the allegations involved, and there were misrepresentations all over the shop in relation to the experience that Mr. Jones brought to bear. There's concern about the fact that the food was so bad that all of the patrons at Mr. Smith's tent deserted his tent and went next door to get better food. And the director of catering and hospitality at the Flemington racetrack, a very important person, complained to Mr. Smith about just how bad the catering was. So Mr. Smith now joins us on the bench. So we're just going to do a couple of areas.
Was it Mr. Jones that?
Mr. Smith. Is that?
So because he's choose. So
Oh, okay.
I look at more about Mr. Jones, but I can try
Happy
it.
to be Mr. Smith?
Sorry?
Are you happy to be Mr. Smith?
I'll try, but forgive me if I forget that.
Yeah. All right, now, Mr. Smith, you seek to contend to his honour that Jones find who misrepresented to you the nature and extent of their catering experience, correct? Now, you, of course, have seen the statement of Mr. Jones in these proceedings.
Yes.
And you've seen that he states that prior to 3 November 2015, which was the date of the event, Jones Farm Food catered for about 10 events of between 10 and 50 people, and one large event of about 250 people, correct?
So why we can yes.
Yes. And you have no reason to doubt the accuracy of what Mr. Jones describes as to the nature of their prior experience in catering, do you?
You are for that particular statement, no, nothing on the book.
And you agree with Mr. Smith that no one on behalf of Jones Farm Food ever made a representation to you to the effect that Jones Farm Food had more experience than the experience Mr. Jones describes in his affidavit, correct?
Sorry, just to clarify, so you're saying that have I heard from anyone from John's Fine Food that on connect to what Mr. Jones is?
Precisely.
So I have spoken to the sales manager and the administrator of Jones Fine Food before the event happens, and what they told me is for general, as in that they are very experienced in this service, but I have never been told precisely how many events they have been to.
Thank you, Mr. Smith. So in light of that, I take it you would agree with my proposition that no one on behalf of Jones Fine Food ever made a representation to you which was inconsistent with what Mr. Jones describes in his affidavit. You agree?
Yes.
Now, just on this, you say that on the 3rd of May 2015, you met Mr. Sellers, the marketing manager of Jones Fine Food, and met with him, correct?
So you want me to the statement with I.
Yeah, in fact, I might, in light of the time, I might stop that line now. Okay, I don't know. I'll just stop there now and just have a brief overview of that one. Very good witness. So you thought very carefully about the question. What is really good? You didn't understand the question. One of them that I asked at first, and then you asked it to be clarified, and you did so by saying, "I mean by that question this," and that complied with the critical. You never answer unless you fully understand the question. So very good points for that. You were very careful at first in answering the question and distinguishing between the very precise description of experience given in the affidavit, and you said, well, nobody contradicted that specifically, but they gave me more general, they made general statements about the extensive level of their experience, and that was very good to draw that distinction. But I sort of was ultimately able to extract a concession from that nobody misrepresented to you the nature of their experience, because after you made that very careful distinction, I then put you in a tone of voice which clearly suggested, of course, the answer is yes. I said, well, of course, you would agree in those circumstances that nobody made a representation inconsistent with what Mr. Jones describes. And I presented it in a way which, that's pretty obvious, isn't it? And you delivered back the answer I wanted. Yes, I agree. And in actual fact, you could have stood your ground and drawn the distinction between the number of functions they said and the broader, more general but extravagant statements that we had lots of experience. And you could have said, well, no, I disagree. And then I would have been forced to ask you the next question. Well, why do you disagree? You could have said, well, to be perfectly honest, Mr. Sellers said they had lots of experience. Now, if I'm organising a high-end catering event for the Melbourne Cup, and this refined institution tells me they've got lots of experience in relation to catering, well, mate, I construed that as being much more than 10. So if you're asking my opinion, I think they misrepresented it when they said lots. So you could have held your ground a bit there. All right. But generally, a really good, careful, considered response to questions. It just does reflect the vulnerability to being, in a sense, seduced or coerced into acquiescing. All right. Now, Mr. Smith, you seek to bolster your complaint about Jones Fine Food by contending that Miss Trotter, the Flemington Director of Hospitality, corroborated the complaint about inadequate catering. That's the case, isn't it?
What was the mechanism?
You seek to bolster your complaint about Jones phone food by contending that Miss Trotter, the Flemington Director of Hospitality, corroborated your complaints about the inadequacy of the catering. That's the case, isn't it?
Yes.
Now, Mr. Smith, before I ask you any further questions, I'll give you the chance to reflect upon that position.
I think my affidavit has summarized the facts that I heard with this.
Mr. Smith, while you're in the witness box, do you wish to withdraw your allegation in this court that Ms. Trotter complained to you about the inadequacy of the catering?
No.
You want to stand by that allegation, do you, Mr. Smith?
Yes.
I want to suggest to you, Mr. Smith, that Ms. Trotter did not make any statement to you which clearly conveyed her view that the catering was inadequate. That's the case, isn't it?
No, I don't believe so.
Mr. Smith, in your statement, you comprehensively set out each and every relevant conversation you had with Ms. Trotter, don't you?
Summarize what I have discussed with Mrs. Trotter. You can point me to the specific parts that you are referring to.
I'm asking you, there is no material conversation you had with Ms. Trotter about this issue which you left out of your statement, is there?
Summarize the conclusion of the conversation, but I did not make a detailed meeting notes on it.
And there is no material aspect of that conversation which you left out in your description, is there?
No, not anything I think would be relevant to this case.
Mr. Smith, please take me to the paragraph in your affidavit where you contend to His Honour that Ms. Trotter alleged to you that the food was inadequate.
It would be paragraph 17 to 19, where I discussed about my communications with Mrs. Morgan.
And paragraph 17 is the only one in which you purport to describe conversations with Ms. Trotter, which she allegedly made allegations about inadequate catering, correct?
So please give me some knowledge. This is business and cooking. Yes, that would be paragraph 17.
And in terms of the issues which you say she raised with you, all you report her saying is in the final sentence of paragraph 17, which is, quote, apparently Mrs. Trotter had heard we'd been having some issues and she came to see me about them, close quote. That's all you report her saying, isn't it?
Also, in the sentence before, Mrs. Trotter has spoken to me during the course of the day and asked me about it.
Yes. But in that sentence, there is nothing, is there, to suggest that she was raising with you any allegation about the inadequacy of the catering, is there? And in relation to the last sentence, apparently Mrs. Trotter had heard we've been having some issues and she'd come to see me about them. In that sentence, she doesn't report any personal concerns about the quality of the catering, does she?
Not in the sentence, yes.
So the answer is no. You agree.
What is the
You agree that she does not say anything. You do not report her saying anything about her personal concerns about the catering, correct? And she merely reports that she, quote, had heard we'd been having some issues, close quote. That's all she said, wasn't it?
There are some elaborations behind this sentence, but this summary, a fair summary of what he said, what she said in that meeting.
And she did not disclose to you the persons from whom she had had any reports, did she?
No, she hadn't.
She didn't report to you the number of people that had allegedly made reports to her, did she?
No, she hadn't.
And she did not describe what the issues were, did she?
She has gave some examples are issues. Not a complete report on this.
Are you now suggesting, Mr. Smith, that there are other material parts of your conversation with Ms. Trotter that you now allege, but which you failed to record in this affidavit? Is that what you're saying now?
I think this sentence summarizes what our conversation covers, but I haven't specified all the issues discussed.
I suggest to you that when she raised with you issues, she did not specify what those issues were. That's the case, isn't it?
Not agree with statements because I think it would be possible for Mrs. Trotter to discuss the issues with me without some specific examples and issues that she found. It is only that we haven't summarized that and elaborate them enough in this statement.
Mr. Smith, I'm not concerned with your hypothetical speculation about the difficulties she might have in raising discussions with you. I'm putting to you that she did not specify what those issues were in your conversation. That's the case, isn't it?
That's correct. It specifies examples of issues in our conversation.
And I suggest to you that your suggestions to His Honour that the conversation included specific examples that you did not refer to in your affidavit is nothing more than pure fabrication, Mr. Smith. That's the case, isn't it?
No one disagrees.
All right, we might stop it there. You did a good job. Thanks. You held your ground very well there. So how did it feel?
I can do the U-turn to get me to
I get you in the corner, then slaughter you. So that's so no, it was very good effort. And what gave you the wiggle room was that when I asked, because what council tried to do, it's 2 o'clock, a bit, just a couple more minutes, or what they try and do is that you could close the gates, which means we effectively want to eliminate any wiggle room you have to get out of a difficult situation. Now, the reality is you're in a difficult situation in paragraph 17 because all you say is that she raised issues. And you don't specify what those issues were. And so it's not at all clear that the issues related to catering. And the fact is you were encountering buckets of issues on the day because your patrons were flooding next door. And so that could have been an issue she came to. So what I wanted to be able to get you to concede is that there was no discussion by Ms. Trotter in which she specifically raised concerns about the inadequacy of catering. And I can do that if I committed you to paragraph 17 being an entirely comprehensive statement of your recollection of conversations. But what I tried to put to you was you said, well, it's an accurate summary, but I didn't include all of the details, but it summarises the gist of the conversation. And that's got an up and a down from your perspective. The down is that it may look as though you're trying to leave wiggle room, and it leaves you open to the suggestion that you introducing recent fabrications as you expand your evidence in order to save yourself. But it magnificently gives you the ability to say, well, when Ms. Trotter talked about the issues, she said there were three. She thought the caviar was very soggy. She thought the drinks were warm, and sort of the prawns were poisonous. I didn't put them in, but that's what she said. And so it gives you, it leaves the wiggle room. So it reflected a very good listening to the question and understanding what it required, and realising that there was something you could do to avoid getting boxed in. Did you have that in your mind when you responded that way, or?
Yes, and I was thinking whether I should try making up some ease.
Yeah. Well, what
creative.
I would have got used to that. So what do people think of how Vivian went?
Very well.
You can social engineer.
No, it's good. That was a very good job. And in terms of what level of, if any, of anxiety and pressure were you feeling in the course of that? Did you feel anything which sort of impacted upon your capacity either to think clearly or to present your answers in a way that you felt was appropriate and optimal, or were you feeling more control the whole way?
Definitely, it's quite anxious experience.
Yeah.
Mr. Smith didn't even know who he was.
Surprising him.
Mr. Jones. But definitely, like the way you phrase the questions and the way you put it differently. For example, the first line versus the second line. With the second line, you're like obviously more pushy.
Yeah.
That make me more anxious too.
Yeah. Anyway, great job. So, I mean, it is just a good experience to feel what that's like. So, well, thank you very much for your attendance and your attention. Any queries arising from all of that? I know you've moved to get back to, but I'm happy to take questions now if anybody would like.
I mean, this hypothetical seems, could these personas be more accurately categorised as lay witnesses rather?
Yeah, good. Definitely. Yeah.
So what would be different about being cross-examined as an expert? Are you more likely to get questions about your experience and your level of qualification?
Good question. I mean, this is useful for just generic managing of cross-examination techniques, but if you're an expert, there will be additional lines of cross-examination which will relate to your specialised knowledge, whether it's appropriate for the subject matter you opine on, the specification and the substantiation of your assumptions, the logic of your reasoning process, the investigations you undertook. So there'll be a sort of a whole raft of issues that are unique to experts, but and generally these days the cross-examination of experts is relatively civilised in a hot tub where experts are in there together. They're not being grilled individually by counsel, and there's a general perception that has sort of changed the tone of cross-examination, and it's a much more respectful and civil exchange of ideas rather than a very forced, closed interrogation, which cross-examination used to be. All right. Thank you all very much.
Thank you.